Welcome everyone. Today is the last of our session of contract classes for this go around. Today we are going to talk about miscellaneous disclosures, the SBSA, and a few other things. So it should be a fun call. After each contract or each page, if you have any questions, please type it in the chat box and we will try to answer it as we go along. So today we are starting with the SBSA. The SBSA is the mother of all disclosures. It is 14 pages and it basically covers everything and anything. Everything here is probably covered someplace else also. That's the one thing about disclosures is you will see it at least 3 or 4 different places. This form does not replace the local condition disclosures, which we also have and we'll talk about a little bit later. Basically, I'm just going to go over the highlights. You should retain your own professional, even if seller or broker has provided you with existing reports. So just because we have disclosures, just because we have the TDS and SPQ, buyers should still be doing their own inspections, their own due diligence on all these deals. You have the right to request that the seller make repairs or corrections or take actions based on the inspections, but the seller is not obligated to respond. So you do your inspections, you do a request for repairs, the seller can either agree, disagree, move forward, or in some cases, the seller doesn't even respond. And most likely they do respond, at least letting you know yes or no. If the seller is unwilling to satisfy your request at that point, you can either cancel the contract as long as you're still in your timelines and move forward, or decide what you want to do. Seller's rights and duties, okay? So you have the seller always has to disclose everything they know about the property. Whether they think it's going to affect the deal or not, they still should disclose it. If what's important to the buyer may be different than what's important to you, so you definitely need to disclose everything. The broker. Many defects and conditions may not be discovered by the broker's visual inspection. We as agents do what's called an AVID, which we went through before. And then again, that is just a visual inspection. We are not experts. We're not going to go on the roof. We're not going to inspect the water heater, the air conditioning unit. We are just doing a visual inspection to see what we note. Any questions on that page? All right.
We're good.
Moving forward. This is, and just to give you a heads up, this is what the new RPA is going to look like in another year, where it sort of gives you a table of contents of where everything is in the document. That's why this became now 14 pages, because it is table of contents, which is pretty useful. So if you want to look where investigation of physical conditions are, these are the sections that take care of that. Legal requirements, these are the sections. And that's what made it now 14 pages. Yeah. Inspections. Buyer and seller are advised the buyer has the right to obtain various inspections. You can, you do your home inspection. If your home inspector says, you should have a roof inspected, make sure you get a roof inspection. You can have as many inspections as you write during the time period that you have your inspections, which is typically 17 days. Mold, which is a four-letter word in our community. Mold can only be determined by an expert. If you see something, you can't say, oh, that's mold. We are not experts, we don't know. So if you suspect there's mold, your buyer suspects there's mold, they should have someone come out and inspect that and make sure if it's safe mold, toxic mold, there are different levels. Pets and animals. Seller needs to disclose if they've ever had pets on the property, how many pets. Some people may be totally allergic to cats, and if there was ever a cat there, that might be an issue. Pets also have odors from urine and other contamination. So the seller needs to disclose that, not just, yes, we had pets, How many pets, what type of pets, makes a big difference if you had fish as a pet versus dogs and cats as a pet. Septic systems. Many homes, depends on your area, are on septic systems. Give you an example, we had one home here, it's in middle of Newhall, all the homes around it were on city. This house was on septic, no one knew it. So make sure that your buyer, your seller understands if he's on a septic system, he needs to disclose that, needs to let them know where it is. The buyer, if it's on a septic system, should have a septic report done. So it identifies it, pumps it, certifies it, everyone's happy. Square footage, lot size, boundaries, and surveys. This has become a big issue. You list a property, the tax record shows 2,300 square feet. The buyer says, oh no, it's 2,700 square feet. We don't know what it is. There's actually a form now to be used that states this is all the different square footages that we know. This is where it came from. It came from an appraiser. It came from, a lender. It came from the city. So this is, it shows you everything that's out there and where it's disclosed. We're not experts. We're not certifying anything. We're just saying this is the information out there. Well and water systems, same as septic. If you have a well, disclose it. If you're buying it, make sure you have that tested. How many gallons is it producing? Is there issues with the well water? Those are the things that need to be determined before you purchase the house and also needs to be disclosed. Wood destroying pests, termite inspection. You could always ask for the termite inspection in the RPA. Do not ask for Section 1 in the RPA because now we are asking the seller to agree to something that he has no idea how much it's going to be. You ask for the inspection. Later on, when you get the inspection back, you can do a request for repairs and say, we'd like Section 1 done. The seller knows how much it is. They could agree, disagree, negotiate. Hot topic these days, accessory dwelling units. If you have one, discuss it, let everyone know about it. When you have your inspections, make sure you inspect the ADU also. If you are planning to put an ADU in a property, make sure you have the ability to do that. That's another thing too, is when you're purchasing a property, if you say, hey, I'm going to purchase a property, I want to put a pool in. Make sure you can get the permits and all that to put the pool in. Don't find out later, oh, I can't do what I wanted to do, and now, we have an issue. So if you want to do certain modifications, additions, moved your, 2-story instead of 1-story, make sure you can do all that before you purchase the property. Because after you purchase the property, it may become an issue if you're not able to do what you want to do. And this deals with, city codes, HOA codes. There are a lot of different levels of things you want to do. California Fair Plan. California Fair Plan is, if you're unable to get insurance or fire insurance for your properties, you can go to California Fair Plan, and this way they will insure you, but again, there is a cost. When there's more risk, the cost for insurance goes up. So look at this when you're buying a property to ensure that, yes, I can afford the insurance and I still want this property. Certain properties, due to the location, their fire insurance may be outrageously priced and you may not afford it, or you may not even want to take it on. But learn these things before you purchase the property. Heat and ventilation, cooling systems, these are all things that are going to be done with your home inspection. Insurance, title insurance, and title insurance after foreclosure. Again, when you purchase a property, you're going to get a preliminary title report. You will get a clear title. If there's been a foreclosure on this property, it may be a little bit more of an issue. So always work with your title company to make sure you get the report. Make sure you look at it, make sure there's no liens, nothing out, that may be an issue. We had one where there was a judgment against the owner for a business he had. He never knew about this. Now all of a sudden his house is not sellable because they want more money to clear the judgment than the house is worth. So it became a point where it was impossible to sell the house. Marijuana is legal. Cannabis and methamphetamine labs are not legal. People can grow marijuana for private medicinal uses. There's different rules and regulations. I have an area up here in Acton, Agua Dulce, and Palmdale, Lancaster, where people are looking for land to grow marijuana and have these marijuana grow houses. If you're doing that legally, make sure it's allowed if you're going to buy the property for that purpose. Owner's title insurance. Owner's title insurance protects you to make sure there are no liens or anything on the property, make sure there's no outstanding grant deeds. So it protects you going forward with this property to make sure no one's going to come back and say, wait a minute, I really own this property. How did you get it? Another big item right now is rent and eviction control laws. If you are buying a property that has a renter, if you're buying a property and you're thinking of turning it into a rental, look at your local ordinances and laws to see what rules you have to follow, what are the current laws. Right now we have a few deals where we can't move forward because the renter's in there, we can't evict them. This deal's basically stalled until someone figures out where the renter can go, because there's really no place to go, and how we can make this deal happen. Retrofit building requirements and point of sale. This is more in LA City. They actually have a retrofit and a point of sale requirement that makes sure you have gas shutoff valves, tempered glass, low flow toilets, low flow showers. So if you're buying in a property where you're not sure, make sure you talk to someone and find out what are the requirements. Are there any retrofits that need to happen? Are there any inspections that need to happen? Is it a point of sale? In California, we have a requirement, for water conservation toilets and showers. But at this point, it's not a point of sale requirement. It's just a question. Do you have them? Are you aware of them? Yes or no? In LA City, it's actually a point of sale. Short-term rentals and restrictions, Airbnbs. So if you're buying a property and you're saying, hey, this would be a great Airbnb, I'm going to turn it into one. Again, make sure your HOA allows it. Make sure your city allows it. Make sure everything you want to do with that property, do all your research up front and make sure you're able to do what you want to do. Views. This is another one. Person bought a new development up in Castaic. Beautiful view. 5-6 years later, all of a sudden the trees are now growing. That view is now gone. So, just make sure you know what's going on. The HOA planted the trees for privacy for other people, but now it's infecting their view and now it becomes an issue of what they purchase as a beautiful view now is just a view of trees. Melrose. We have a few new developments out here that have Melrose, where the fees go in to help build the infrastructure for the community. Melrose usually lasts anywhere from 20 to 25 years. There is on the NHD report a table for taxes where you can look up your Melrose. There's a phone number. If the buyer's interested, they can call up, find out how long the Melrose for. Does it escalate? Is it a flat rate? Is it renewable, or after the term it's over, how much time is left? Again, the buyer can do that, not you as an agent. It's the buyer's responsibility to look into these things. You can direct them where to get this information from. Golf course disclosures. I love this one, and we actually have this on our Everest Addendum also. If you live near a golf course, your house may be hit by golf balls. Just be aware of that. Noise and lighting. So again, look around your surroundings. Don't be surprised one day and all of a sudden your back window's broken because a golf ball came in. It's like, yes, you knew there was a golf course. Yes, there was a possibility that would happen. So again, look at your surroundings. Had a deal, person bought a house next to a indoor soccer facility where it was an enclosed facility. A few years later, this whole community complained about the lights. The soccer facility was there before they bought the house. So it's nothing new. So again, look at your surroundings. Certain things are not going to change.
Hey, Fred.
Yes.
I just wanted to chime in to Talene on
Sure.
something. I did a mock trial at the board a few years ago with a couple of lawyers. And in the trial, the seller had several broken windows from golf balls, and they did not put that on their TDS. And of course, the buyer moved in and they started getting, because they were just in that range of the area where they kept coming in their yard. The buyer started having broken windows and they sued him and they won because it was supposed to be put on the TDS that was a problem. So
Right.
just a little heads up on that one.
Yeah, so even though we have all these disclosures saying this, if you have firsthand knowledge of it happening to your property, you need to disclose that. You know, you can't use the argument, well, you know, it's in the disclosure someplace. Yes, but you know specifically it's been happening to your property, so you need to disclose that. And that's the one that always gets me is the golf course, because you know it's there, you know it's going to happen, but neighborhood.
As long as you tell them you've had issues and let them make the decision. That's right.
Definitely. Yep. Okay. Neighborhood area, personal factors, buyer intent. You know, we know there's a high-speed rail that's supposed to be coming eventually one of these years. Some HOAs have smoking restrictions. You know, so again, be aware of your surroundings, read the HOA rules, see what's going on. Neighborhood noise. Okay. This is a big one. If you know your neighbor has a barking dog and it barks every single night, you need to disclose that. You need to disclose if your neighbor has a party every single weekend or even once a month if he has a party. Your neighbors will talk and they go, yeah, that party's been going on for years. Disclose it. You know, right now, a lot of schools are shut down. This also happens a lot during the summer. If you know that when the school is in normal session, you have a parade of cars up your street because of your school, disclose that. We have an area in our location, I'm sure everyone else does, you know, like a Christmas tree lane. Okay. During Christmas, people cannot get out of their house because of the traffic, but they know that when they're buying it. Disclose it. If I'm looking there in August and I'm from and out of the area and I don't know about this street looks lovely. Come after Thanksgiving, it's a worst nightmare if I didn't know about this. You know, one, I may not participate. Two, it may impact me coming in and out of my house. If you disclose it, people know it, they buy it, everyone's happy. Death on the property. Technically, 3 years. You need to disclose their death and you don't have to disclose the reason. But again, some cultures, no matter how long there's been a death, they still won't buy the property. So here's up to you. You know, this is, again, legally 3 years. I would disclose forever because your neighbors will talk. You know, if you have long-term neighbors, they'll talk about it. Just disclose. EPA and lead-based paint. Okay, this only applies pre-1978. We're going to talk about another form later on that needs to be filled out. But if your home is before 1978 built, we're going to talk about this form on what needs to be filled out. Fire hazards, again, NHD report's going to disclose it. But again, if your house was evacuated last year, you need to disclose that because that could affect people getting insurance and insurability of that property. Flood hazards the same way. You know, NHD report's going to report where a flood hazard is. If you get your NHD report and it shows it, Talk to your insurance company and see if there's anything special you need to do. Megan's Law database disclosure. Megan's Law is a great resource. However, as a realtor, you should really not be looking into it, because if you know about it, you have to disclose it. If your clients are interested, you can point them to the website and they can do the research themselves. Notice the supplementary property tax bill. Basically, when you buy a house, you're paying the taxes on the old price of the house in escrow. You will get another bill going forward for the supplemental difference. This does not come out of escrow. So explain to your buyers that when you get this bill, it's important that they take care of it, not assume, oh, I have an escrow account account's going to take care of it. So just let them be aware that this bill may be coming and to take care of it when it happens. Arbitration. Arbitration is part of the contract. Mediation is optional. Arbitration basically is a step before you go to court. You're in front of an arbitrator. You both argue your cases. You present your facts. And then they make a ruling, and usually it is a binding arbitration. Home warranty. We recommend that the seller always buys a home warranty for a few reasons. One, it protects them for a year in case all of a sudden the water heater doesn't work, the air conditioner doesn't work, the dishwasher. Who's the buyer going to make the first call to? Their agent. Their agent will call you and say, hey, we just bought this house 2 months ago and now the dishwasher didn't work. You must have known it didn't work. Home warranty takes care of that. If they do the home inspection and it shows that it worked on day one, then they go to the home warranty, and home warranty should take care of the issue. Since we are a Crest E&O company, if you add the Crest portion to your home warranty, that increases the coverage for the buyer, and it gives the seller 6 months of E&O coverage, and it helps you in case we are sued with your deductible for E&O. Liquidated damages. Liquidated damages is, again, an optional signature in the contract. What liquidated damages is, if everyone agrees to it, if for some reason the buyer is not able to perform and they remove their contingencies, the seller is entitled to up to 3% of the purchase price or whatever, or the lesser amount of what's in your EMD. So if you put less than 3% as your EMD, that's what they're entitled. If you put more than 3%, they're only entitled to 3%. They don't have to prove any losses or anything like that. If they don't do liquidated damages, the exposure is unlimited, but the seller has to prove financial damages at that point, which is a lot harder.
Fred, just
Yes.
a reminder, because I get this almost every week.
Sure.
With liquidated damages, if there's a dispute between the buyer and seller, in order for that money to be released, both parties have to agree for it to be released to one party or the other.
Correct.
So when you guys are talking about this clause with your clients, it's important to know that, yes, technically they may be entitled to it, but it's only if both parties agree to release it from escrow, which is a little bit trickier of a process.
Right. And if it's not released, it stays in escrow till either, someone brings a case against them, or escrow sends it to the state after 5 years, and then it goes there. Mediation. Mediation is a step before arbitration. Mediation is a independent mediator, hears both sides of the cases. They're not going to make a decision. They're there to help you resolve and come up with a solution that's workable for both sides. As opposed to arbitration, where arbitration is going to make a judgment, mediation is just going to facilitate the communication between both parties. This is another fun one, non-confidentiality of offers. For some reason, agents believe that they cannot disclose they have other offers or what the other offers are. Only if the seller specifically says, please do not disclose our offers in writing, and says, please do not disclose what they are. Otherwise, we're allowed to, and sometimes it helps. I mean, if I know you have 3 offers over asking, I'm not going to tell my buyer to say, hey, let's come in under asking, maybe we'll get lucky. It saves a lot of time, because then you'll get serious offers. If I know, they're all over asking, I'm not going to, and my buyer knows he wants to come in under, I'm not going to even write an offer. I'm going to say, you know what? There are 3 offers over asking. You have a little chance. If he still wants to write, there's nothing we can do, but at least we have the information that we can talk to him about it. Online and wire fraud fund transfers. This is a big issue. Okay, there's a lot of wire fraud going on. We do not deal with wire transfers. We never want to know the instructions. We never want to see the email about it. Just let your clients know, both buyer or seller, it happens on both sides, that if they get instructions, they need to call the escrow department that they're working with, not the phone number on the email or however they got it, but the escrow department that they know, and confirm that this is legitimate instructions and confirm the numbers. Once funds are transferred out, they're basically gone. It's amazing. These things look so real that even escrow companies have been duped, and it's pretty scary out there. Private transfer fees, we talked a little bit about in the RPA. There are certain new construction firms, this is not so much now, but in the past, where they set up this nonprofit organization, and anytime that property is sold, a percentage of the sale, which is a transfer fee, and it's usually less than 1%, usually like 1/4%, goes into this fund. But again, it's recurrent. So even 10 years from now, when that property is sold, this fund is still being active. Homeowners associations, read your CC&Rs. Read everything in that HOA. If you want to put in a electronic charger for your car, make sure you're able to. So, there's a lot of restrictions. There are good restrictions, bad restrictions, but there are restrictions for HOA and CC&Rs. Make sure you understand it all when you purchase the property. Marketing and internet advertising, and internet blogs and social media. Again, this is another big issue. Buyers and sellers need to be advised. Once we put stuff out there, we have no control over where the pictures are. Zillow still shows stuff as active that we sold 2 years ago. We get calls from buyers saying, hey, my property's on the internet. There's pictures out there. I'd like you to take them down. We really don't have control of that. Once it's out there, and they just have to understand that. PACE loans and liens. This was a great program a while ago. It's been abused a lot. Basically what it was a way for you to do energy improvements on your home. Solar panels, windows, new air conditioning. I've even seen it used for artificial grass. Anything that's going to conserve energy. The downside to it was it's attached to your taxes, which what happens is now creates a super lien. So this lien goes above the bank's lien. So what happens is no bank's going to lend on you because they could be foreclosed on without even knowing about it. So this looked like a good issue, but they needed to put a little more monitoring in place, and there's been some legal cases going on. But again, if you walk up to a house, they have a new AC, they have new double pane windows, they have a new solar panels, just ask. And again, it's on the listing agreement. How did you get this? Is it a HERO loan? Is it a PACE loan? If it is, it's most likely going to have to be paid off before you can transfer the property. Normal things, rekeying. When you become the owner, you should rekey everything. We have no idea where those keys are, who the previous seller is giving keys to, how many people have those keys. Rekey everything. Change your garage door opener remotes, should be recoded. Anything that other people have had can now be used to get into your property. Make sure you take the property proper precautions. Recording devices. Always assume when you go on a property, you are being recorded, whether it be a Ring doorbell, whether it be, cameras in the house. There was a case where, a buyer and their agent were talking in the kitchen. They said, let's offer this, but we go up to this amount. Lo and behold, the offer came back, counter offer came in, and it was the exact amount they were asking for. So they were being monitored, and there was actually a lawsuit about that. So when you're in the property, when you're near the property, on the driveway, just assume you're being recorded. Watch what you're saying, because everyone's watching you at that point. Everyone's got to sign that, buyer, seller, both agents, and that's the 14 pages. Like I say, everything in this disclosure is at least 2 other places, but this sort of puts it all together in one place. The Century 21 Everest Addendum. This addendum serves 3 functions. One, it is actually a disclosure, and it has some local disclosures specific to our area. It is also a business advisory saying these are the businesses we deal with. And it also states there is a processing fee for of $3.95 for handling and record keeping and that. So it does a few things. A lot of people go, well, I'm buying in, San Bernardino. This doesn't apply to me. True, but it also has other disclosures, so they still need to sign it. Escrow process is complex. Just letting them know that. The wire fraud advisory, like I said, buyer's initials, seller initials. This has become a real big issue lately. Purchase or sale by one spouse. If one spouse is buying a property, the other spouse is going to have to do a quick claim deed, but escrow handles that. This is just letting them know that's an issue. So these are things that are transparent no matter where they're buying the property, whether it's Ventura, Santa Clarita, San Bernardino, Long Beach. These are still disclosures that need to be made. Digital processing fee. This is the fee I've been talking about. Photography and internet advising. Again, this is just stating we have no control over the pictures once it's out in the World Wide Web. It's out there. It's very hard to take stuff down. Mandatory government retrofit and report requirements. We saw that up again in the SBSA. Homeowners Association. We only have a one-liner, but again, it's the same thing. If you live near a golf course, you may be hit with golf balls. Earthquake disclosure. NHD is going to tell you, yes, there are earthquakes. Just depends. Are you on liquefaction ground? Other things. Do you want to get earthquake insurance? Does your condominium take care of it? Different areas to look at. Metrolink Railway. Again, something that's supposed to happen. We have no idea. Rocketdyne Santa Susana facility. This was a plant that tested rocket engines. I guess they had contaminated land. We have one over here called Termite, which we're still trying to clean up the land. So again, it's just disclosing these are issues. Parking enforcement. I know there are certain cities like Santa Clarita has a RV parking enforcement. Looks like Thousand Oaks and other areas. If you have an RV, research what the requirements are in your area. City of Thousand Oaks has a record search and report city inspection. Ventura has a sewer lateral ordinance. OI has, sanitary district. High winds, we have high winds. Oak tree, we have an oak tree ordinance. You guys have an oak tree ordinance. if you're buying a property of oak trees and you want to do stuff, make sure you can do it. I sold a property in a Newhall. The oak tree was on the other person's land, but the oak tree was going into our fireplace. To get that thing trimmed, we had to get permits, had to have an arborist come out. It became a big ordeal. So just realize when you're dealing with oak trees, there are a lot of steps to take. You just can't trim it off and say, okay, we're done now. Gas shutoff valves are required in LA City. They're not required in Santa Clarita or other areas yet, but that's going to be changing. We have county jail facilities on Pitchess. The Termite disclosure, that was the land I was talking about out here that they're still trying to clean up. Saltwater pools are no longer allowed in Santa Clarita. Saltwater softeners are no longer allowed either. Again, the only person, both people need to sign it because you want your buyer and seller, no matter who you're representing, to know these are the disclosures. The only one we need the information on is whoever you are representing. If you're representing a seller, we've had buyers say, well, wait a minute, I'm not paying the $395. No, they're not. Only the person that you are representing. If you represent both sides, then both sides are paying the $395. This is the other part of, like I said, there was 3 parts to our Everest Addendum. This basically states these are companies we do business with. Every real estate company has their own business disclosure statement saying these are the companies we do business with. These are their fees that they charge down here. Doesn't mean, like we get calls, oh my God, what's this 0 to 10%? I'm not paying 10%. No, this is a price range. If it's, land, vacant land, could be 10%. Otherwise, it's somewhere between 0 and 10. NHD reports, Inspiro Financial, these are their fees, All Valley Escrow. So again, it's just disclosing these who we have a business relationship with, and also these are the fees at this time. Again, everyone signs, everyone initials. Market conditions advisory. This basically says the market is a cycle, goes up, goes down. Offering price. We never determine what the offering price is. We work with our clients and we say, look, this is what homes around the market have sold. You have seen the property you're interested in. What would you like to offer? Because the minute we say something, if they don't get the property, it's like, well, we didn't offer enough. You told me not to do that. If they do get the property and they go, wait a minute, maybe we offered too much for it. So if it's their decision, we're just giving them the information to make that decision. Non-contingent offers. We're getting a lot more of those in today's environment. Non-contingent means if you can't get a loan, you're out of luck. If it doesn't appraise, you're out of luck. Again, these are very specific offers. You really need to talk to your clients. Yes, they may get the property, but it may cause a whole nother issues down the line. Okay? If they remove their appraisal and it doesn't appraise, are they willing to come up with the difference? Because you can't cancel now because you removed your appraisal contingency. If you can't get the loan because all of a sudden, your income is diminished due to COVID or something like that. Again, you removed your contingencies. The contingencies are there to protect the buyer. So be very careful when you remove them or shorten them. If you're shortening your loan or appraisal, talk to your lender, make sure it's a possibility. Again, we recommend you do not write a non-contingent offer. We recommend you have a professional inspection of the property. We recommend you assess your financial position and risk with your attorney. So, again, we want to protect the buyer. We know in today's market, things are crazy. Buyers feel they got to do everything to get the property. We are getting a lot of buy remorse after it's all happened. They got caught up in this whirlwind. They go, blah, 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 blah. They got it, and now it's like, oh my God, what did I do? Did I really want this property? It has these problems, you know? So we are getting a lot of buyer's remorse. It's amazing how much has been happening lately. Again, sellers, we don't determine the asking price either. We lay out, this is what's selling in your area, this is what is sold, this is what your competition is. Where would you like to price your property? Because if we say a price and they sell in one day, oh my God, we sold it for too low. If we say a price and it takes a month to sell, oh my God, you listed it too high. Again, we help them make the decision. We let them come up to the conclusion. Lead-based paint, like I said, this only applies to 1978 and before. I see a lot of agents use this for every deal. It really doesn't apply, only if it's before 1978. So what it basically says is before 1978, lead-based paint was allowed. Okay, so was your house painted with lead-based paint? I'm an hour. I'm on training. So, you know, if the house was painted with lead-based paint, did you use it correctly to remove the lead-based paint? You know, did you follow the EPA standards? You know, and that's basically what it's saying. I have no knowledge, or you do have knowledge. You know, do you have reports? You know, was it taken care of directly, or did you just have a handyman come scrape off the paint and now you put another layer of paint on? This becomes issues when it's pre-1978 because you may have had lead in that paint. Okay, again, for sale transaction, buyer acknowledges they have 10 days. So if they're buying a house before 1978 and they want to have a lead-based paint inspection, they have minimum of 10 days or whatever in the contract. Typically, it's a 17-day inspection, so they can look at it. If it's before 1978, we recommend that if they want to waive it, that it is checked saying the buyer waives the right. Otherwise, they're going to come back later and say, well, wait a minute, I didn't know I could have done an inspection. And then that becomes an issue. Verification of property. This is another one that's a little misunderstood. The verification of property typically happens 5 days before you're ready to close escrow. And all this is you are looking at the property for a few reasons. One, is the property in the same condition when I made the offer? You know, is the pool same, or is now the pool totally green? Did they turn off the water and now all the landscaping is dead? You know, did they put holes in when they were moving out? So this is just saying, yes, the property is substantially the same condition as when I purchased the property. Also, the biggest issue too is buyers are saying, well, I don't want to look at the property until the sellers move out. Unfortunately, in today's environment, sellers may not be moving out until the day of escrow, or if they have close of escrow plus 1 or 2, it may be after. So you need to inspect your property while there's stuff still there. The other thing you're looking at is the seller's completed all the repairs, alterations, you know, any replacements, anything that you asked to be done, the seller has done and completed. So it's not to find new issues. It's not to do a new inspection. It is just to look at, this is the stuff I've asked to be done. This was done. The house is in the same situation of when I purchased it. Yes, it is now. So it's not to find new stuff. If you do find new stuff, you know, like all of a sudden there's a hole in the wall that wasn't there before, document it. Both sides have to sign it. And then, you know, we have to decide, how do we handle it? Do we move forward? Do we take care of it after escrow? Do we hold up escrow? at that point, it becomes an issue of how we move forward on this.
And Fred, with that, just a comment, a
Sure.
lot of agents wait until the day before escrow closes to do your walkthrough.
Yes.
The contract says you can do that up to 5 days prior to the close of escrow. Here's the problem when you do it the day before escrow. First of all, the loan has funded for the buyer, so the buyer is paying interest on that loan. Secondly, if you do it later in the day, if you find an issue, maybe the repairs weren't done or there's something like really huge that you don't want to close and fix it after because that's not the most opportune thing to do, you have a problem because you can't pull that recording. Your loan is funded. You can't pull the recording. The escrow is closed. They can't drop an amendment for both parties to sign and come to agreement on. So now we are closing and we have a major issue that's unresolved. So just be proactive and do your walkthrough at least a couple of days prior to the close of escrow, and then we won't be running into those issues because they do. I just had one come up yesterday. So a common thing because of waiting until the last minute to do the walkthrough.
And like I say, a lot of buyers also want to wait till the seller moves out.
Right.
And that may not happen right away. So.
Set up the expectation right from the beginning. And the one I had yesterday was the same thing. That particular client, he number one, he wanted to go in after they moved out, and then he wanted money, but he had had a bad experience and he was just not being very cooperative. But set the expectation up with your clients right from the get-go and explain to them that we will be doing this walkthrough several days before the close of escrow, and this is what you should expect from it. It's not to open up new things, etc. So it's just educating them and setting the expectation ahead of time.
Exactly. Notice to buyer to perform. So again, this is from the seller. And again, like I tell my agents, we are just dealing with the contract dates. This is not personal. This is not, oh my God, we're going to cancel. This is just saying we are dealing with the contract dates. These dates have now come. Please do whatever the contract says to do. And there's a ton of choices. Did they put their deposit in with 3 days? If not, give a notice, talk to them, notice to perform, saying, you know what, escrow's waiting for your deposit. We need to know your money's in the game. Did they, return the lead-based disclosure? Did they, show evidence of the seller's sale of buyer's property? So there are a lot of different things. Did they deliver the representative capacity signature? This is a big one. We have deals that are in a trust, both revocable and irrevocable, and we don't have an RCSD to say who really can sign for this deal. So we don't know if we truly have a legitimate contract going. Contingencies. Is it past their 21 days? Is it past their 17 days for appraisal? Is it past their disclosure reports to return stuff? The HOA documents, title report. So it's just managing the contract timelines. It's nothing personal. It's just, hey, you were supposed to remove your appraisal at 17 days. Here's a notice to perform. Let us know what's happening. Doesn't mean we're canceling. We just have our seller's best interest in mind, and we want to prove we are managing the contract. And they have 2 days to take care of the issue, or if it's been changed in the contract, whatever days have been agreed. Can't be less than 2 days. Okay? And again, days start, if I give the notice to perform today, tomorrow is day 1. Saturday, Sunday, Monday is day 2. Because don't count weekends where the thing ends.
Yeah, the final day cannot fall on a Sunday, a
Right.
Saturday, Sunday, or a holiday. And I just had one over this Labor Day weekend that it was issued on a Friday, and because of the holiday weekend, that means that it was not expired until 11:59 on Tuesday. So
Right.
just remember that a lot of people think every day counts. It doesn't. If the final day, that second day is on Saturday, Sunday, or a holiday, it goes to the following business day.
Correct. Okay, and now it's the seller's choice to, give a notice to perform. Did they, so me as a buyer, I'm supposed to get my reports in 7 days. My disclosures. Did I get my disclosures in 7 days? No. Then you still have your 17 days inspection. So if they're taking 7, 8, 9, 10, you still have 17. So you just lowered the amount of time you have to review your disclosures. So again, it's just saying, this is the contract we agreed to. Please provide, HOA docs. HOA docs is a big one. Takes a while to order. Make sure you get it as quickly as possible, because if you get it past 17 days, I can't remove my disclosure for HOA docs because I have not received them yet. So again, this pushes everything down the timeline. Are they having a final replacement property? Did they remove that contingency? And again, this is a 2 days unless it's different in the contract. And last but not least, when all the notice of performs are done, we give a demand to close. Okay? So the seller hereby demands that the buyer close escrow on this property within 3 days or the close of escrow date, but no earlier. Okay? So you can give it, if this deal's really going south and really going, not well, you can give it 5 days before, but you can't ask them to close until the close of escrow. Again, same, or by a specific date. So like I say, you can give it 5 days before, but this date has to be the close of escrow. You can't ask them to close earlier than what the contract has agreed to. The buyer can do the same thing on their side. They can say, you know what, I don't see you packing. I don't see stuff moving. I want to make sure we're closing escrow on time. I'm giving you a demand to close. Make sure it happens. Okay. And confirmation receipt just to make sure, to confirm we have got it. And we have gone through all the contracts. Are there any questions on these or any other contracts that we've talked about? Nothing. All right. Is anyone still there, or? Karen, are you still there?
I'm still here.
Okay, I just want to make sure I'm not just talking to myself for the last half hour.
No, definitely not. I'm listening to everything you're saying. It's awesome. Thank you.
Okay. Well, thank you all for joining us. Like I say, we're going to put the schedule together for the next round. We're going to work on, reviewing what we've done and figure out how we can improve it. Thank you for your participation. And as always, also, if you have questions, please reach out to myself or your managers. We'll be happy to help you. Karen is going to, after this, put this in our YouTube channel. So you will have the full.
They're actually already in there. So
Right.
If you go to YouTube and you go to Century 21 Everest Training, and then go to CA Training, California Training, and hit the playlist, you will see all the different classes. This one will be loaded up probably by tomorrow. So you'll be able to reference and go back and listen to all of the ones that we've done since the beginning.
All right. And again, thank you. Have a great day. Have a great weekend. Try to stay safe with the strange weather that we're having out there. And look forward to the next time. Bye.
Thank you.
Thanks, Fred.